He will die in prison, and that is a good thing for the safety of the community.
Rob the purity of a 9-year-old child to gratify your own perverse sexual pedophilic needs.
Alcohol is just an excuse. Alcohol doesn't make you rape a child.
In August 2017, Brandon Lee Cantley, 33, forcibly entered the Dry Creek, Raleigh County residence of a 91-year-old woman and her caregiver. Armed with a weapon found within the home, he assaulted the two women, demanded money, and confined them in the home before fleeing with cash, jewelry, and a 2001 Jeep Cherokee. The prosecutor revealed that the elderly victim endured severe emotional trauma, marked by recurring flashbacks and a constant sense of fear. Both victims continued to struggle with distress and the lasting psychological impact of the incident.
She's having some flashbacks in the night, and she said she could feel him touching her, and that's the silent harm that we don't see.
At his sentencing in January 2018, Cantley listened as the judge listed his charges, including first-degree robbery and kidnapping. Before leaving the courtroom, Cantley apologized to the woman's family.
Cantley will be eligible for parole after serving 10 years of his life sentence. Does not mean he's guaranteed parole.
He faced 9 charges, but pleaded guilty to kidnapping. The court sentenced him to life in prison with the possibility of parole after 10 years. Cantley was sent to a maximum security prison to begin his sentence. Former Atlanta police officer Justin Thorne was convicted of his role in a 2019 armed robbery involving rapper Freddie Gladney III, known as Bankroll Freddie. The robbery happened at a Cobb County motel as Freddie and his cousin were preparing to leave. Security footage showed Thorne parking near the attacker's car and acting as a lookout on the motel's 4th floor. He later knocked on Freddie's door, helping set up the crime. Freddie escaped without injury, but his cousin was repeatedly injured.
He said, "I'm here for suspicious activity going on up here." So I said, "What you mean? We headed out. We're packing our bags. Suspicious activity, just me and him." My cousin comes to the door. "Hey, this is my room. What's going on?" Guy come from the side. You already know what time it is.
Thorne's lawyer claimed he acted under threats to his family, though the source of the threats was unclear. Just 2 weeks before the robbery, Thorne had resigned from the police force while under investigation for allegedly offering to take a bribe to clear a suspect's warrant. The police continued investigating the involvement of the two attackers, and it was unclear if they had been charged or arrested. Justin Thorne was sentenced to 10 years in prison after pleading guilty to helping orchestrate the armed robbery. Cleotha Abston admitted his guilt in the kidnapping and murder of Eliza Fletcher, a case that captured attention around the world. He pleaded guilty to several charges, including first-degree murder for killing Fletcher, especially aggravated kidnapping for abducting her, and a firearm possession charge related to his use of a weapon during the crime. Eliza Fletcher, a 34-year-old woman, was kidnapped and during an early morning run in September 2022. Her family shared a heartfelt statement in court, describing her as a bright and loving person whose kindness, faith, and compassion touched the lives of everyone she knew. They expressed how deeply they miss her and how her loss has affected her family and everyone who loved her. While no legal resolution can heal their pain, they took comfort in knowing that Abston will remain in prison for the rest of his life, unable to harm anyone else.
He, the guy that just pled guilty and is going to jail to die, he's not really even part of the story, right? The story should be about Liza and the love that she brought and those kids that her and Rishi have and growing up. And now this guy can just be forgotten because he's going to prison to die.
We looked at the evidence and realized that it was going to be an impossible case. And we built up a relationship with Cleotha and explained to him that words to the effect of, "Man, this is not going to end well. We need to resolve this."
Prosecutors emphasized that this was an important step toward justice. They urged people to focus on Eliza Fletcher's legacy and the love and positivity she brought to her family, friends, and community.
He will die in prison, and that is a good thing for the safety of the community.
Already serving an 80-year sentence for a 2021 rape, Abston was sentenced to life in prison without the possibility of parole for the murder. He also received an additional 40 years for kidnapping and 8 years for a weapon-related charge. These sentences will follow the 80 years he is already serving. Dr. Stephen Matthews, once a respected cardiologist, was convicted of 35 charges, including drugging and assaulting women he met on a dating app. He portrayed himself as a successful professional and outdoor enthusiast, but behind this image, he was a predator who spiked drinks and attacked his dates.
I got in the hot tub, and the very last thing I remember is just looking at the water and then just lights out.
One of his victims, Audrey, courageously shared her experience. She recalled losing consciousness after getting into a hot tub on their first date. Her mother later found her disoriented and partially dressed in the shower.
She was in the shower, half clothed, and just making no sense.
Audrey's bravery in speaking out led 10 more women to come forward, accusing Matthews of similar crimes. Prosecutors believe there may be dozens more victims who have not come forward. The women reported similar experiences, waking up groggy after a date, unable to remember what had happened.
You really made a difference here.
It was not easy. It was not an easy decision, and it was not an easy road. But I knew it was the right thing to do, and I stuck to my guns, and I did it.
At his sentencing, Matthews wept as his mother begged for leniency.
It would be improper if you did not serve a sentence for each victim individually. The total number of years are 158 years in prison. This matter is concluded.
However, the judge underscored the gravity of his actions by sentencing him to 158 years to life in prison, ensuring he will never be released. Matthews' lawyer announced plans to appeal, but the sentence guarantees he will remain behind bars. While the pain he caused cannot be undone, the victims found some solace in knowing he can no longer harm anyone else. Michael Peach admitted molesting a boy and threatening the boy's family to cover up his crime. During the sentencing, Trumbull County Judge Ronald Rice condemned Peach's actions, calling him a monster and ordering him removed from the courtroom.
You robbed the purity of a 9-year-old child to gratify your own perverse, sexual, pedophilic needs.
The boy's mother shared her emotional account, explaining how Peach had groomed her while they worked together at a job that encouraged employees to bring their daughters and sons.
What I didn't know was I was being groomed and set up to practically hand deliver my son to a predator.
I can only pray for forgiveness and that I alone, no matter what sentence I get, I'm going to have to live with for the rest of my life anyway.
After the assault, Peach broke into their home weeks later, attempting to intimidate the family. His plan was stopped when the boy's father intervened and risked his own safety to protect his family.
Mr. Peach, you made a statement to the police being interviewed that you were a monster. This court fully agrees with you that you are a monster.
I think Judge Rice's sentence today sends a message that this isn't going to be tolerated in Trumbull County.
Peach pleaded guilty to 18 felony charges and acknowledged that the harm he caused could never be undone. Judge Rice made it clear that Peach's actions would not be tolerated and was sentenced to 48 years in prison. Prosecutors expressed hope that the sentence would send a strong message against such crimes. Brianne Altice, 36, is a former English teacher at Davis High School in suburban Salt Lake City. She was accused of having sexual relationships with 3 boys in 2013 and 2014. Prosecutors alleged she continued a sexual relationship with one of the boys while out on bail, leading the judge to revoke her release. During a hearing, an 18-year-old testified that he and Alti had engaged in sexual contact several times. This testimony followed her earlier arrest for similar allegations involving boys. Prosecutors argued she was a danger to the community, a claim her attorney, Ed Brass, denied.
Why is she not a danger?
Why is she not a danger? She's harmless.
Do you anticipate her ever testifying?
We'll have to see about that. That decision hasn't been made.
But she might.
We'll see.
Altice pleaded guilty to 3 counts of second-degree felony forcible sex abuse. Each count carried a potential prison sentence of 1 to 15 years. Judge Thomas Kay ordered 2 of the sentences to be served consecutively, with the third running concurrently with the first 2. However, she applied for parole after 4 years of her sentence. During her parole hearing, Altice expressed remorse for her actions and stated that her time in prison had helped her develop self-confidence and self-compassion. In April 2019, after serving around 4 years in prison, the Utah Board of Pardons and Parole granted Brianne Altice parole. Her parole was granted after the board evaluated her rehabilitation efforts and the impact her actions had on the victims. She was released on September 10, 2019. A Queens doctor faced accusations of drugging women, including his patients, and secretly recording videos of sexual assaults. He appeared in court to face new charges, and one victim shared her story. Dr. G. Allen Cheng, a gastroenterologist, had been indicted for the third time. He was accused of using his position as a doctor to sexually abuse and rape both patients and others. One woman said she woke up after a routine colonoscopy to find Dr. Cheng violating her.
He targets people that are helpless. I was in the recovery area with the curtains drawn, and Dr. Cheng was giving me a vaginal exam.
Previously, in August 2023, Chung faced an indictment for allegedly sexually abusing 3 hospital patients and for drugging, raping, and recording assaults on 3 other women at his home in Queens. Earlier, in December 2022, he had been indicted for reportedly raping a female acquaintance in his apartment. Prosecutors claimed he drugged and sexually assaulted more than 14 women, with many incidents caught on video found in his possession. Attorney Nicholas Liakis represented some of the alleged victims. Some victims only discovered they had been assaulted after seeing the evidence provided by investigators.
One of the first victims that came forward was not aware that she had been or victimized until she was shown a video by the district attorney's office.
I reached out to the Queens DA. They showed me a screenshot of one of the videos he had, and they asked me to identify myself, and I did.
Several victims filed lawsuits against New York Presbyterian Hospital Queens, saying the hospital ignored warning signs. In 2021, a 19-year-old patient reported being drugged and raped in a hospital exam room.
With the curtains drawn, and Dr. Cheng was giving me a vaginal exam.
The hospital later fired Dr. Cheng and issued a statement apologizing to the victims and their families. He has been indicted on multiple charges related to sexual abuse, but has not yet been sentenced. He remains in custody without bail and is awaiting trial. If convicted, he faces numerous sentences of 25 years to life. A 23-year-old man from Hollister, Jonathan Fidone, was convicted of sexually assaulting his girlfriend's daughter. Despite the verdict, Fidone spoke in court, insisting he was innocent and claiming the trial was unfair.
I don't recall a victim of this young age for the sex acts of a baby. It's very tragic.
The incident occurred in the summer of 2010 when Fidone's girlfriend left her daughter in his care while she visited her mother in the hospital. During the trial, Fidone's cousin testified that he witnessed the assault. Prosecutors revealed that the girl suffered physical trauma as a result of the abuse. In July 2011, a jury found Fidone guilty.
First, I want to say I'm sorry things had to go this far and that now people's lives are ruined for a crime I did not commit. So with what life I have left, I'm going to fight to clear my name as an offender and to clear Jane Doe's name as a victim.
The San Benito County judge described Fidone's actions as egregious, highlighting how he betrayed his girlfriend's trust to harm her daughter. Fidone was sentenced to 23 years to life in prison. Judge Gregory Moeller called the case of 32-year-old Marcos Navarrete Zamore one of the most heartbreaking and horrific he had ever seen. In court, he told Zamore that he had destroyed a girl's life by raping her, which eventually led to her becoming pregnant. The judge described the unimaginable trauma the girl endured upon learning she was pregnant by her stepfather and the overwhelming pain of carrying the pregnancy to term.
I can't even begin to understand as an adult man the horror for a girl to discover that she's pregnant with her stepfather's child. And the pain and difficulty of someone so young and immature and carrying that child full term.
Zamore, an undocumented immigrant, was arrested after the girl's younger brother reported the abuse to the police. Zamore's attorney argued for a sentence of 5 to 10 years in prison, while prosecutors pushed for 20 years to life. Before receiving his sentence, Zamore apologized in court and admitted to the harm he had caused.
I know this has been very difficult. I understand my mistake.
Judge Moeller sentenced Zamore to 32 years in prison, with 10 years fixed and 22 years indeterminate. Zamore was also ordered to register as a sex offender and pay restitution, with part of the payment going to the girl. Jeremy Guthrie, a former Water Authority employee, was convicted of raping a girl. The case began with a 2022 traffic stop, where police discovered Guthrie driving drunk with several boys and girls in his car.
You have a bunch of kids in the car. How many kids? You have 1, 2, 3, 4, 5, 6. Who are these kids to you?
This is my friend.
Investigators later uncovered that he had been engaging in an ongoing relationship with one of the girls, leading to his conviction on 9 counts of rape.
She's going to have to remember this for the rest of her life, something that no child should ever have to go through.
During sentencing, the prosecution sought the maximum penalty of over 112 years, emphasizing the lifelong trauma inflicted on the victim. Guthrie's defense requested a lighter sentence of 12 years, citing the challenges of the COVID-19 pandemic and claiming his actions were influenced by loneliness and alcohol. Prosecutors rejected this argument, stating that neither the pandemic nor alcohol could excuse such crimes.
People who were already lonely were even lonelier and could have resorted to drinking, as Mr. Guthrie looks like did in this particular situation.
COVID didn't make other individuals children. Alcohol is just an excuse. Alcohol doesn't make you rape a child.
Guthrie's family also pleaded for leniency, with his ex-wife, a survivor of sexual abuse and now a social worker, asking for a reduced sentence for the sake of their son.
I know most people don't believe that Jeremy deserves a second chance, but I sure hope that they believe that his son does.
Before being sentenced, Guthrie apologized to the victim's family, expressing regret for his actions. However, prosecutors criticized his apology as insincere and lacking accountability.
I want to apologize to the family and everyone for all the problems that I caused. That was never my intention, but I'm truly sorry. So.
That was a half-ass apology from the defendant. He didn't take any responsibility for what he did.
He was sentenced to 36 years in prison. After serving his sentence, Guthrie will remain under strict supervision and must register as a sex offender. An Abbeville County man appeared in court facing charges after his dogs brutally attacked Kylene Waltman, a mother of 3. The incident occurred while Kylene was walking along a road in Honapath. Her family revealed that the attack was severe and she remains hospitalized.
This is the most horrific thing I've ever seen. Knowing Kylene, she's not going to want to live. She's not going to want to live like this. She's got too much pride to rely on someone else.
Right now it's killing us. She didn't deserve it. She was a good person. She helped everybody.
Deputies reported that 3 dogs, 2 of which were pit bulls and 1 a mixed breed, attacked her. The dog's owner, Justin Miner, faced charges including owning a dangerous animal that caused harm to a human. The dogs involved in the attack were seized by animal control following the incident. Kylene's family expressed their heartbreak over her injuries, describing her as a kind person who always helped others.
You are still a resident of this county. You've got a job. You turned yourself in.
In court, Miner appeared visibly upset as the judge set his bond at $15,000, citing no flight risk since he turned himself in and remains a resident of the county. The judge also ordered him to have no contact with Kylene or her family. Samuel W. Legg III, a former long-haul truck driver, was arrested in connection with a 1997 rape case in Medina County, Ohio. DNA evidence tied him to the assault of a hitchhiker, leading to his indictment. Further analysis of Legg's DNA linked him to several unsolved homicides from the 1990s. One notable case involved the 1992 murder of Sharon Lynn Kedzierski, whose body was found at a truck stop near Youngstown, Ohio. While authorities suspect him of involvement in additional crimes due to his truck driving career, no further murder charges have been filed yet. Questions about Legg's mental competency have caused delays in his legal proceedings. He has undergone several evaluations to determine whether he can stand trial. Investigators continue to review cold cases for potential connections to Legg and encourage anyone with information to step forward. Lana Barton, mother of Lonzie Barton, pleaded guilty to child neglect and lying to police after her son's tragic death in 2015. Lonzie drowned in a bathtub while Barton and her boyfriend, William Reuben Ebron Jr., were in another room engaged in sexual activity. Instead of seeking help, Ebron hid Lonzie's body and falsely reported a carjacking. The case triggered a massive 6-month search that ended when Ebron eventually led authorities to Lonzi's remains. An autopsy could not confirm the exact cause of death, but showed signs of previous abuse. Ebron took a plea deal. As part of her plea agreement, Barton testified against Ebron, confirming her knowledge of his involvement in Lonzi's death. She received a 5-year prison sentence for child neglect and lying to investigators, followed by an additional 7-year term from a separate drug conviction in Baker County, totaling 12 years. Her release is expected in 2027. Meanwhile, Ebron was sentenced to 20 years for Lonzi's death, plus 5 more for unrelated drug charges, bringing his total sentence to 25 years in prison. The case remains a haunting example of child endangerment and the devastating consequences of parental neglect. On June 2, 2023, a long-standing neighborhood dispute in Ocala, Florida, turned deadly when 60-year-old Susan Lawrence shot her neighbor, 35-year-old Ajiki A.J. Owens, through her locked front door. The conflict reportedly stemmed from tensions involving Owens' sons and daughters playing near Lawrence's property. That day, after a verbal confrontation escalated, Lawrence fired a single shot as Owens knocked on her door. Owens later died from her injuries. Lawrence was arrested shortly after the incident and charged with manslaughter and assault. She claimed she acted in self-defense, telling authorities she feared for her life. However, prosecutors argued that her actions were driven by anger and hostility, not fear. The case quickly gained national attention, sparking debates about race, self-defense laws, and neighborly conflict, especially since Owens was a black mother of 4 and Lawrence is white. The trial began in mid-2024, and courtroom testimony included statements from neighbors, law enforcement, and forensic experts. Jurors reviewed Lawrence's police interview, viewed 3D reconstructions of the scene, and listened to audio from the moments leading up to the shooting. The defense presented expert witnesses to support Lawrence's fear-based justification, though she chose not to testify. On a Friday in late August, both sides gave closing arguments.
Jared Gardner told you that he heard Miss Owens say, after she's banged on the door, something to the effect of, "Come out here, bitch," or "Open the door," something to that effect. Jared Gardner told you he never heard Miss Owens say anything like, "I'm going to effing kill you," "I'm going to break down your door," "I'm going to go in your house." He didn't hear anything like that, because those statements weren't made. He heard Miss Owens tell the defendant, "Come outside." You heard from Uriel Rodriguez, 12-year-old Uriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry, it was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, "Come out." And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, "Come out, bitch." Uriel Rodriguez said he never heard Miss Owens threaten the defendant, say, "I'm going to F and kill you, I'm going to bust in your house," anything like that. It was "come out." Miss Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Miss Owens wanted to get into that house, all she had to do was take something from the patio, one of that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that, because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens' mouth. And the defendant said, Miss Owens first said, "I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons." First thing out of her mouth deals with her sons. First thing out of her mouth is not, "I'm going to bust in your house and I'm going to kill you." It's, "I want to talk to you about my sons," just like the last times. You heard from Yvonne Costa, who's the neighbor, had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding. And the pounding was loud. There's no doubt about that. It was loud enough to to, shake the wall between the two of them that they share, and maybe even rattle a mirror. It was loud. But it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, Marion County Sheriff's Office. And in fact, the defendant actually told the detectives she initially thought it might be the law enforcement coming. Why? Because she just called them and knew they were coming. She knew they were coming before she fired the shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that? Or was it just pounding? The defendant's answer was, I just remember her pounding and pounding. You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her phone. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her gun. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim. She leveled the gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found. Because remember, CSI Medina found the .380, the shot that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. That she is behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Miss Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Miss Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable. Because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Miss Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have then been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Miss Owens was about to murder her. Miss Owens had no ability whatsoever to even get into that house, to even try to cause her harm. There is the secure, locked, deadbolted metal door.
The prosecution emphasized that Lawrence fired not out of fear, but because she was frustrated. The defense countered that Owens' presence at the door caused Lawrence genuine panic. Jury deliberations began the same day. In November 2024, Lawrence was found guilty of manslaughter. During sentencing, she addressed the court expressing remorse and stating she never meant to kill anyone.
Children, and it's one of the reasons why I had issues with the gentleman I was with, because he wanted to have another child, and I felt I was stopping him. That said, I would like to make a statement to AJ's mom, children, and friends. It is with heavy heart and great remorse I write this letter to you. First and foremost, I am so sorry that I took AJ's life. I never intended to kill her. The night I shot that gun, I was confused as to why she was screaming and pounding on my door. I had an idea that Israel told her I had hit him. I could not understand why she was so angry. And she truly scared me. Now that I know he told her I hit him, I am just profoundly sad. Not only did a mother die, but a daughter and a sister. I think of your family's loss and know how hard it is to lose someone you love. Not being able to see that person, look at that person, or just talk to that person is such an empty feeling. I so wish I could go back and change things so that she was still here. I would trade my life so that she could be here, if it were possible. I know that you have all suffered from her loss, and I have prayed for you and your family during this time so that you can, that God could help you. Nothing I can do will change the outcome. I can only tell you I have cried and I feel horrible for my actions. Please accept my humble and sincere apology for this tragedy.
You know, it's the facts don't rise to a murder charge, but they are very aggravated manslaughter. Because this case, the shooting was based, I find, more on anger than fear. And I think that's pretty well established in this case. So when I weigh it out, and believe me, I find that, you know, she's a victim of child sex abuse was a significant mitigating factor. And she has no criminal record, which is also a significant factor. However, we also have a tremendous harm inflicted upon this family and the victim's family. So what I'm going to do in this case is she being adjudicated guilty of manslaughter with a firearm in order to serve 25 years in the Department of Corrections. With credit for 538 days. It's $100 cost of prosecution, $100 fine, court cost. Good luck to you, ma'am. You have 30 days to appeal. Is the defense requesting the appointment of public defender for purposes of appeal?
Judge Robert Hodges ruled her action was motivated more by anger than legitimate fear. Prosecutors resisted a lighter sentence, but the judge slightly reduced the maximum, citing Lawrence's trauma and mental health, and sentenced her to 25 years in prison. During a recent Harris County Commissioners Court meeting, tensions emerged over scheduling conflicts tied to Judge Lina Hidalgo's ongoing mental health treatment. In 2023, Hidalgo took a public leave of absence to seek inpatient care for clinical depression. Since her return, she's maintained a standing group therapy session every Thursday from 3 to 4:30 p.m., a commitment she openly disclosed when the court voted to move weekly meetings from Tuesdays to Thursdays. As the May 2025 meeting approached the 3 p.m. mark, Hidalgo reminded her colleagues of her need to step away for therapy, reiterating that this schedule was shared in advance. Commissioner Rodney Ellis proposed a solution based on legislative practices, allowing members to cast votes retroactively after returning, provided the vote outcome remained unchanged.
And as you guys know, I have to take a break between 3 and 4 o'clock. I have my group therapy. We knew this when we rescheduled court for Thursdays. And so that was my asterisk when we decided to move court to Thursdays. So
I'm not, and again, Judge, just a quick question. That 3 to 4 is an important hour. What can we do 3 to 4?
The discussion can continue, right? So Commissioner Ellis runs the meeting, and then you guys can continue the meeting. Oftentimes, somebody's late, we just do that, we discuss. All I ask is that, as I've done when one of you guys is absent and coming back, that you not take the votes and wait until I return to take the votes.
So, Judge, I'd like to suggest, and if there's latitude to do it today in the rules, I'd like to change it today, and if not, do it on the next court. When I was in the legislature and someone had to walk out of the room, we gave people permission, it's in the rules of the Senate, so you could cast your vote when you got back, as long as it did not change the outcome of the vote. If I'm not mistaken, Jay, I know you were there as an intern a long time ago. I think you worked there for a while. But I think that would be good in our rules. Sometimes I may have to walk out, or anybody may have to walk out. And if it changes the vote, that's a different deal. But it would give any one of us the ability to walk out of the room, do whatever you have to do, come back. Am I right, Jay? Am I remembering this right?
No, that's correct, Commissioner, and we can certainly do that. I think for the next meeting, I've already spoken to the county administrator about it. We can make a change to the rules that will expedite that process. Unfortunately, I can't do it for this meeting because there's not a rules item on, but we can certainly have it ready for the next court.
Yeah, and what happened last court that was time consuming is that the court voted while I was gone. Whenever I'm presiding over the court, what makes it quick, and the reason maybe you guys don't remember this, is because I hold the vote. So we discuss, and then once somebody returns, then I say, okay, let's vote on item 3, and we don't have to say, let's vote on reconsidering the vote, and now let's vote. So if you will extend that courtesy to me of holding the vote until I return for this court, it'll be a lot easier.
So what I'm saying is, if we tweak our rules.
Right, so he's going to tweak them for next time.
Yeah.
But he's saying he can't tweak them for this time.
Yeah. If we move expeditiously today, when I looked at the agenda, I think we ought to finish this by 3. We ought to finish it by 2.
And I agree, and I'd even be interested in seeing how much time each of us speak to see who's holding up the meeting, because I know we've tried to cut back on speakers, and really it's the speaking here on the dais. So maybe we'll have someone run that down. All right, so we're gonna invite our public speakers to address the court, and thank you again for taking the time to be here. So Tiffany, if you would please introduce our speakers.
Excuse me, Judge, I think you got folks in the queue.
Oh, Commissioner Ellis, Commissioner Briones, and then Commissioner
I
Garcia.
spoke, I'm sorry.
Thank you.
So County Attorney's Office, similar to what Commissioner Ellis just said, my ask, to the extent permissible, would be a both and, right? So if somebody has an appointment or another commitment that they need to leave, that they be afforded the opportunity to vote when they return. And meanwhile, those who remain can cast their vote as we're discussing things, because it's highly disruptive to go back item by item. And so if we can both and this, so that we can allow flexibility, but also allow maximum efficiency and focus, that would be my strong preference, please.
And that's what Commissioner Ellis explained. That's what I'm talking about. This is what extends the discussion. We already agreed on that.
County staff agreed the rule could be updated, but only at a future meeting since procedural changes couldn't be made mid-session. Commissioner Adrian Garcia voiced concern that losing an hour mid-meeting disrupted his schedule and suggested that votes should proceed, even if Hidalgo was absent.
I walk into these meetings with my day planned, and so today I've already got commitments. If we kill an hour without anything productive, it really sets my schedule up. So I will also like some consideration for my schedule, not knowing that we're going to take an hour out during court meetings. And so I would just say if we can, we're going to change the rule next court. If we can just, if we happen to go into the 3 o'clock hour when you're gone, I would just ask if we could just take votes, and then it's going to be one court. We'll be able to move forward the court after.
Yeah, and you can do that, Commissioner. I'll make sure not to extend that courtesy in the future. But really the concern is, court used to be on Tuesday. The court decided to move our meetings to Thursdays. And so this is not a commitment that came up for me out of nowhere. I did my mental health leave in 2023. I was inpatient for anxiety and depression for 8 weeks. I've been very public about that. And since I returned, I've been doing my group therapy on Thursdays from 3 to 4:30. So when the court said they wanted to move our meetings to Thursday, I said, I have the standing committee, well, I guess it could be a committee, it's a group, the standing commitment that is part of my mental health treatment. So I would just like to underscore that's you, joining the ranks of those who are trying to pick on me over mental health treatment.
Please, we're not going to go there. Look, I got put on the planning commission that is on Thursdays. We moved the court to Thursdays. I can't make all the planning commission meetings, so I have my proxy there. And we're able to continue the business.
I can't send a proxy to my mental health treatment. Yes, Commissioner. Let's just move on. Okay, if you want to have the vote without me, have the vote without me. I'll remind the community that you are interfering with something that I'd mentioned before. And people can see that. People can see your behavior, and I frankly think it's embarrassing, but that's okay. All right, let's move on.
In response, Hidalgo firmly pushed back, stating that her therapy is essential medical care, not a discretionary appointment. She emphasized that mental health treatment cannot be delegated or rescheduled like other engagements, and warned that disregarding it would send a troubling message. While acknowledging Garcia's point about time management, Hidalgo stressed the importance of empathy and consistency, noting that she had always paused votes when other members were temporarily unavailable. The discussion reflected broader questions about balancing efficiency with understanding, particularly when it comes to mental health. Though no new voting rules were implemented during that meeting, the exchange served as a reminder of the challenges public officials face in maintaining personal well-being while fulfilling public responsibilities. On April 1st, 2024, 19-year-old Sade Robinson, a college student with dreams of working in criminal justice, went on a first date with 33-year-old Maxwell Anderson in Milwaukee. They were seen dining together at a local restaurant before heading back to Anderson's apartment later that evening. Surveillance footage and cell phone data confirmed their movements.
2024. Sade Robinson was a 19-year-old young woman. She had an apartment on the Lower East Side, 1858 North Commerce. She was in school, she worked a job, she worked at Pizza Shuttle on the Lower East Side. She was everything that you would expect a 19-year-old girl to be. That day, April 1st, 2024, Sade Robinson went to work at Pizza Shuttle, like any other day, and she made plans to meet up with the defendant, Maxwell Anderson, that evening after work. And she wouldn't know it at the time that she left her apartment that morning, but she would never return. Sade and Maxwell Anderson met up for dinner and drinks at the Twisted Fisherman restaurant in Milwaukee. They then went to Duke's Bar on Water Street, and then they went back to Maxwell Anderson's house on the south side of Milwaukee around 9:20 in the evening on April 1st. After leaving Duke's and going to the defendant's house, Sade would never be seen alive again. That night, she was murdered by Maxwell Anderson. Her body was dismembered by Maxwell Anderson in a vicious and gruesome manner. And then Maxwell Anderson attempted to make her disappear from this world by discarding her body into body parts into Lake Michigan, and then taking her car and burning it behind an abandoned building near 30th and Lisbon.
In the early hours of April 2nd, just past midnight, Robinson's Honda Civic was tracked, leaving Anderson's residence and heading toward the Lake Michigan shoreline. That same morning, a body's remains were discovered on the beach at Warnemont Park in Cudahy. DNA testing confirmed it belonged to Sade Robinson. Later that night, her car was found engulfed in flames near 30th and Lisbon Avenue. Surveillance video showed a person matching Anderson's description walking away from the burning vehicle and boarding a city bus. Over the next few days, additional remains were found along the lakefront, including other remains, some even washing ashore as far as Waukegan, Illinois. On April 4th, Anderson was arrested during a traffic stop. Days later, he was charged with first-degree intentional homicide, mutilating a corpse, arson, and hiding a corpse. A search of his apartment revealed disturbing evidence: blood traces, plastic sheeting, a tarp, containers of gasoline, and a basement setup described by investigators as a kill room. Authorities also uncovered graphic images on Anderson's phone, including photos of Robinson appearing lifeless and vulnerable. Informants later claimed Anderson had spoken about harming a woman and discussed methods of disposing of a body. Judge Laura Crivello initially scheduled Anderson's trial to begin on December 9th, 2024. However, just a week before the start of jury selection, a scheduling hearing was held on December 2nd.
This is a complicated case with a lot of discovery and a lot of material. Information from the state has been transmitted basically throughout the months that we've been handling this case. At some point during that process, there was Mr. Anderson's devices were seized: his Dell desktop computer, his cell phone. In a search warrant was granted for those devices. I'm certainly not a tech expert, but as I understand the process, the warrants that were secured in this case permitted law enforcement to conduct a partial examination of those materials. And I believe a 30-day extraction was performed, at least that's the way I understand it, that was obtained, was turned over to the defense at some point in this process. And what we learned was that Mr. Anderson was alleged to have, of course, he is, as you know, the last person who was with Sade Robinson before she went missing. We learned that there were photographs allegedly in his phone that had been deleted. When we became aware of that information, we hired a friend. Well, we first had to go to the family to discuss our desire to hire a forensic expert because we're privately retained on this case. And so we met with the family. We conducted a broad search for an expert who would have a lab who could actually examine the materials. There are, of course, experts locally that we've used in lesser types of cases who can go to the police department and review materials on like child cases, for example. There's experts who can go to the police department to look at a device. What we needed in this case was a company that had a lab that could examine the raw data itself to help us answer some questions. There were actually a few other questions we had based on our review of the initial report that was provided by the state. When we hired our expert, normally, if there is a normal in this case, but normally what happens, as I understand it with this expert, is material gets transmitted electronically. So a lot of times you get a link from the state, you send it over to the expert. And Mr. Vance Curzan can confirm this, but what has had to happen here in this case has been just because of the quantity of the material, in other words, the size of it, we've had to purchase multiple hard drives, deliver them to the DA's office, have the material copied onto there, and then have those drives shipped to Florida. We've had to do that twice. And this is not a request I make lightly because we've kept weeks set aside for this trial, as has the court, as has the state, as has everybody. And I have to just make the decision to either make the request or not. But to do my job properly, I have to make the request to adjourn the trial. Our expert will not be done with his report or his review by the trial date. He needs another month or so. Now, as I explained in chambers, where we're at in this process is the day before Thanksgiving, Mr. Vance Curzan provided us with a full forensic copy of Mr. Anderson's phone. As we understand it, the Dell desktop computer isn't particularly relevant in this case as we understand it. But our expert needs a full copy of the forensic copy of the phone. So we provided a hard drive. We were given that forthwith, picked it up on Wednesday, overnighted it that same night down to Florida for the expert to review. As of yesterday evening, he didn't have the materials yet. We were checking with him basically every day. And then today he now has it, or his company has it. He needs that and needs to review that in order to be able to finalize his report. The reason why the report is significant without putting every fact on the record is because it potentially is an alibi. Insofar as, and it's not a formal alibi where we would have another person who would say they were with Mr. Anderson when the victim was missing, when Sade went missing. But our expert believes that there's evidence on Mr. Anderson's phone that suggests that he was using the internet, presumably at his home, during the time frame that another person would have been driving Miss Robinson's car around. So we've asked him to finalize that report. He did provide a draft report. I don't believe I have any discovery obligation to turn over a draft report. Frankly, I don't think I do, but I turned it over right away because I just wanted there to be transparency here with what we were striving to have done, which was to have this report finalized, hopefully before trial, to move it along. But there's a balancing act between moving it along and doing it right, and I need to do it right. So I got the materials to the expert. I've given a copy of the draft report to the state. My expert tells me that he will have his review done, and I have no reason to believe it wouldn't be done within the next 30 days or frankly a couple of weeks. The state's expert, Juan Luis Villegas, who's with DCI, is also based on the draft report rebutting that. What I'm going to do, or what I think would make the most sense, they're going to have that report to me by Wednesday, we think. So that will be transmitted, as I think what we're all doing here is transmitting each other's material so that the experts can have everything they have. And we'll go from there. If my expert is going to be helpful in light of what the state's analyst rebuts, he would be available for the dates that we had tentatively looked at, which was that last week of May, early part of June. Those we did ask, Your Honor asked us to check, we checked. Those dates would work with our expert.
Anderson's defense attorney, Anthony Cotton, requested a delay, explaining that a Florida-based forensic expert had only recently received Anderson's complete phone records. The defense argued these records could provide an alibi by showing Anderson was online at home during the time Robinson's car was seen being driven elsewhere. Despite opposition from prosecutors, the judge granted the delay, emphasizing the importance of a fair trial and the need to avoid potential issues on appeal. The trial was rescheduled for May 27, 2025. Despite the delays, justice moved forward. On May 27, 2025, jury selection began for Anderson's trial.
You are first going to hear about April 2nd, 2024. Around 5:20 in the evening, the Milwaukee County Sheriff's Office and the Cudahy Police Department were dispatched to the shores of Lake Michigan near Warnemont Park. It was a particularly rainy day. The weather was pretty nasty that day. And two young men were walking the shores of Warnemont Park, and they found a human leg. And they called 911. That leg that they found would later be confirmed through DNA testing to be the leg of Sade Robinson. The leg was found down a large bluff at the park on the coastline of Lake Michigan. It's a very secluded location. You are going to see ample amount of photographs of that location. And investigators searched that area north and south of there significantly, thoroughly, but found no other human remains at the park. Now, this park and this location is near the Cudahy Water Department. Investigators also discovered that on April 1st into April 2nd, A vehicle had been used to ram the Service Gate Road near the Cudahy Water Department pump house. This is right next to, about 100 yards away from where the leg was found on the coastline. The Cudahy Water Department personnel reported this actually the morning of April 2nd, prior to the leg being found. Notably, where this gate was smashed, this gate takes you essentially down a service road that goes right down to the shoreline where this Cudahy Water Department pump house was located. And recovered right where this gate was smashed were pieces of a dark blue Honda Civic, 2020 Honda Civic. Sade Robinson had a dark blue 2020 Honda Civic. The pieces of that Honda Civic were recovered from that location. They were ultimately determined by an analyst from the state crime lab that they were not just from any Honda Civic, they were broken off of Sade Robinson's Honda Civic. Video was recovered from the Cudahy Water Department and the surrounding area. And the video showed that near the location of this gate, a dark blue vehicle, Sade Robinson's Honda Civic, entering the park and entering that service road where that gate is at 2:53 a.m. on April 2nd. The vehicle remains down that service road, and there's only one way in and one way out, down that service road for about an hour and a half, and departs that very same service road at 4:32 a.m. on April 2nd. Additionally, on April 2nd, just hours after that car departs the park, at 7:30 a.m., Sade Robinson's Honda Civic was intentionally set on fire behind an abandoned building near 30th and Lisbon. Later that day, April 2nd, 2024, Sade Robinson was reported missing to the Milwaukee Police Department. Friends and family, friends who knew she hadn't shown up for her work shift on April 2nd at Pizza Shuttle, hadn't heard from her, reported her missing. Police followed up. They checked her apartment at 1858 North Commerce Street. She wasn't there. No real signs of what happened. Police would then follow up on the missing persons report, speak to several family members and friends, and discover that she had gone on a date the evening of April 1st, after her work shift. They also learned what her phone number was, and they learned from her family and friends that she had an app called Life 360. Life 360 and the phone number, with that information, police obtained phone records from Verizon Wireless, the wireless company that serviced Sade's phone. And those phone records from Verizon Wireless and the records from Life 360 provided very crucial information about Sade Robinson's activities on the evening of April 1st and her whereabouts. Notably, the police discovered a text message conversation between Sade and a phone number that the police would later learn belonged to Maxwell Anderson. The text conversation showed that Sade and Maxwell Anderson were planning to meet at the Twisted Fisherman that evening to get food, and indeed did meet around 5:15 p.m. on April 1st.
Prosecutors presented extensive evidence, including GPS data, surveillance footage, forensic results, and expert testimony, although no single weapon was recovered, and the exact cause of death remained unconfirmed. The jury was persuaded by the totality of the evidence.
Calling State of Wisconsin versus Maxwell Anderson, case 24, CF1692, appearances.
Ian Vance Curzan and Megan Newport appear for the state along with Detective Joanne Donner.
Good morning, Anthony Cotton and Jason Finley with Max Anderson. Good morning again.
And good morning to all of you. At this point, I have received verdicts. They are in a proper legal fashion. Who is my foreperson? May I have your name and number for the record? And you did sign these 4 verdicts and date them today? I did. Thank you. I will now read them into the record. As to count 1, the verdict reads, we, the jury, find the defendant, Maxwell Anderson, guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, We, the jury, find the defendant, Maxwell Anderson, guilty of mutilating a corpse as charged in count 2 of the information. As to count 3, we, the jury, find the defendant, Maxwell Anderson, guilty of arson of property other than a building as charged in count 3 of the information. As to count 4, we, the jury, find the defendant, Maxwell Anderson, guilty of hiding a corpse as charged in count 4 of the information. At this point, I will poll the jury. What that means is as follows. I'm going to have the first juror stand in the back row on the far right. I'm going to ask you your juror number, and I'm going to ask you, well, stand, and your juror number?
45.
Juror 45, were these and are these your verdicts?
Yes.
Thank you. Next juror.
Juror 23.
Juror 23, were these and are these your verdicts? Thank you.
Juror 29.
Juror 29, were these and are these your verdicts?
Yes.
Thank you. Juror 47, were these and are these your verdicts?
Yes.
Thank you. Juror 3, were these and are these your verdicts? Thank you. Juror 42, were these and are these your verdicts? Thank you. Front row.
Number 5.
Juror 5, were these and are these your verdicts?
Yes.
Thank you.
Number 1.
Juror 1, were these and are these your verdicts? Thank you.
Number 52.
Juror 52, were these and are these your verdicts?
Yes.
Thank you.
Juror 40.
Juror 40, were these and are these your verdicts?
Yes.
Thank you.
Juror number 21.
Juror 21, were these and are these your verdicts?
Yes.
Thank you.
Juror 36.
Juror 36, were these and are these your verdicts? Thank you. State, are you satisfied with the polling?
Yes.
Defense, are you satisfied with the polling?
Yes, Your Honor.
Then at this point in time, your service is complete. You are done for 4 years. At this point, you are free to talk to anyone you choose or speak to no one. It is completely in your discretion at this point in time.
On June 6th, after less than an hour of deliberation, Maxwell Anderson was found guilty on all counts. Sentencing is now scheduled for August 1st, 2025. A separate civil proceeding involving the Robinson family is set to be heard on August 15th. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.